next case to come before us is Summit County Children's Services versus Samantha Ward. Each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please keep your voices up and remain behind the podium. Please do not use the names of children or victims or minors in your argument. You can refer to them by initials like the child or terms like the child. The judges have read your briefs. We're ready to proceed when you are, and I would ask the appellant counsel, would you like to reserve time?
I would like to reserve 5 minutes, please.
Okay, 5 minutes for rebuttal. And please introduce yourselves when you get to the podium.
Okay. Your Honors, opposing counsel, may it please the court, Attorney Angie Killey on behalf of the mother appellant, Samantha Ward. The issue that I would like to present to the court today is actually assignment error number 2. I would like to address the issue with reasonable efforts as it relates to this specific case. I'm sure the court has reviewed everything and is aware that this case has been pending for a very significant amount of time, including one prior reversal by this court for a 12-22 violation. It's once the case was returned to the trial court, it is our position that there was an additional error, and that is with a finding of reasonable efforts. Certainly understand that there's well-settled law that says that there needs to be no requirement to determine reasonable efforts at a permanent custody hearing if there has been a previous determination of reasonable efforts. But it's our position that there has not. Every time an agency files a case plan in one of these cases, it needs to be finding of reasonable efforts as it relates to that case plan, as it relates to compliance and how the agency has been working with the family. There were previous findings of reasonable efforts prior to the first permanent custody decision. Once the case was sent over here and the appeal was pending, the case plan that was put into effect had a goal of adoption. So clearly it had absolutely no objectives that related to a parent or any type of a reunification standard. Once the case was returned to the trial court, said case plan was never amended until 2 weeks prior to the next permanent custody trial. Due to that case plan being filed so late, there was no determination made as it relates to that specific case plan. And we also think the timing of it is a little suspect, as it doesn't really give an opportunity for a parent to be able to work towards reunification if they don't know what it is that the agency and the court is wanting them to do, or putting them in a position where they're able to work any services. The reality is it appears from the time that the case came back to the trial court up until the trial that there was nominal contact with mother. There didn't appear to be any indication that CSB got any documentation about any services mother had been receiving, because she was on felony probation, and a lot of what they would have wanted her to do was being accomplished through the probation department. But none of that had been obtained through the agency to be able to verify. There's nothing in the record that indicates that there was any attempt by the agency, the guardian, or anyone else to potentially modify or revisit the issue of whether or not mom was able to have any visitation with the child. So mother was never even allowed to see this child the entire time that we were pending again. It's impossible to reunify with a child when there's no relationship being permitted to take place. Judge Teodosio did express during the trial in the transcripts that she was concerned about the fact that there was an adoption case plan in place on this case up until 2 weeks before the permanent custody trial. And there is some conversation from the caseworker that he discussed it with mom earlier than that, but a discussion off the record is not a case plan that's been filed in compliance with law. So in this instance, the court had actually asked the parties to file some briefs. It looked like the state might have filed a position on that. The other parties chose not to, and the court never actually ruled on it. What she did instead is made a reasonable efforts determination during her permanent custody decision. So although she's not required to, it's our position that because the court did make a reasonable court's finding in the permanent custody decision, that finding is then subject to appellate review. Talking about a very short span of time that was in, and the finding that Judge Teodosio made based all of it off of the agency's efforts to provide for the child. And of course, the agency does have to put forth effort to provide for a child, but when they're the custodian of that child, they also have a legal obligation to provide housing and services and everything that that child needs. So our position would be that without any effort as it relates to a parent and or reunification, that isn't reasonable efforts. The case law in this jurisdiction says that reasonable efforts are when the agency must diligently and provide services to the family's needs to prevent the child's removal or as a predicate to reunification. So our position would be that mandates they do something as it relates to the parent. And in this instance, there really isn't anything. There's very little conversation or contact between the agency and mother. And of course, some of that is mother's issue too. I understand that. But to me, I think the agency had to make some sort of an effort to work with the mother, to provide her with services, to make her understand what services still needed to be done, to readdress the issue of whether visitation is appropriate, something during the additional almost year that this case was pending after it was sent back, and then didn't take place. Based off of that, we would ask this court to make a finding that the trial court abused its discretion in making that reasonable custody determination. Nobody has any questions for me. I'm going to rest on my brief as it relates to
And that was going to be
assignment
my
one.
question. I don't think your brief clearly indicated what you thought the standard review was for this, but you think that abuse of discretion standard, I may have said in your brief. but-
Okay, and I apologize if I did. Yeah, I believe it's an abuse of discretion.
Yeah, okay, thank you.
Okay? Anything else? No? Okay, thank you very much.
You will have your full 5 minutes left.
Okay.
May it please the court, Evan DiMartino on behalf of the appellee, Summit County Children's Services. We are asking that this court affirm the trial court's grant of permanent custody as well as the trial court's finding that the agency engaged in reasonable efforts. With regard to the second assignment of error, as indicated in the brief, the agency would respectfully submit that once this case was reversed and remanded, the prior case plan that had been filed in 2018 would have been back in place as the case plan relating to adoption would have been rendered moot by the appeal. The trial court did make a finding of reasonable efforts prior to the reversal. The court did find that there were reasonable efforts to finalize permanency in its journal entry. There is no requirement in statute or case law that says that if there has been another case plan filed by the time of the permanent custody, that the court then has to find reasonable efforts based on that amended case plan. That could have been put in the statute, but it is not there. So while appellant's argument is certainly an idea, it is not one that is rooted in law by cases or by statute. Case plans are often amended along the way, and if the legislature wants to require that every time there's an amendment, there's another finding of reasonable efforts, that certainly could be done and could have been done, but it has not been done. With regard to mom's visitation, the transcripts indicate that the therapist from Village Network is aware, as well as everyone who testified as far as the guardian ad litem and the Summit County Children's Services workers, that this child has developmental issues and has been triggered due to developmental trauma. And when she visits with mother, her behavior afterwards is maladaptive, there's issues with violence, etc. Therefore, the therapist did not want to force anything as far as counseling involving mother. And at a team meeting, they decided that they would also not have visitation with mother because the effects on the child were too great. And at the end of the day, the standard is what is in the best interest of the child, not the best interest of mother or father or anyone else. And in this case, the best interest of the child, until it is therapeutically appropriate, is for the child to not engage engage in counseling and/or visitation with mother because it sets back her progress too greatly. With regard to the trial court's finding of permanent custody, the court did consider the case plan, but it also considered, as I just stated, what is in the child's best interest. What happens when the trauma triggers a reaction in the child, the inability for the child to progress and make developments with regard to her mental health. There was testimony that it would take years of counseling for the child to move forward. A mother did have case plan objectives, as well as referrals were made to help her get help. She was still testing positive for illegal drugs. So if there are no questions, the agency would respectfully rest on the brief and ask the court to find that the grant of permanent custody was supported by the greater weight of the evidence and that the trial court's finding with regard to reasonable efforts are appropriate and it was not an abuse of the court's discretion in making that finding.
Hearing no questions, thank you, Attorney DiMartino.
Thank you, Your Honor.
Attorney Kelly, you can proceed with your rebuttal.
I have no rebuttal, Your Honors. Thank you.
Okay, thank you both very much for your presentations. The court will take the matter under advisement and issue a decision in due course. The court reports will mail a copy of the decision to you on the day it's released, and the opinions will also be posted on the Ohio Supreme Court website. The court is now adjourned.